are we going to universally require passwords and logins and that sort of stuff? So it's not just the physical place that we have to worry about. So I think that we have to really worry about some of these kinds of things, and here's the atmosphere that those specific issues are unfolding in. We are immersed in secrecy throughout the federal, state, and local governments today, often for national security reasons, often for privacy reasons, often for other reasons. But when our courts have to operate in that kind of environment, there has to be some concessions to that also. And sometimes those concessions, to me, are just scary as all get out. We've talked about sealing and secrecy, but another aspect that we have to worry about is supersealing. The cases that start the local level, go up through the appellate level, and arrive at the Supreme Court without any notice to the public. We have dockets with no case number, no parties, no facts, no judge, no attorneys, and no documents referred to. We have computer records altered, courtrooms closed, names of attorneys not revealed, defendant and his attorney put under gag orders. And this is just one case that I'm talking about. We have no idea how many others there are like that because they're secret. You can't know what you can't know. This case, the MLB versus Warden case that reached the Supreme Court 2 terms ago, those were the kind of conditions that accompanied that. That was secret filings before the Supreme Court, a one-paragraph brief by the Solicitor General, that sort of stuff. You can search the federal court database to this day and in vain not find anything about that particular case. And even the parties to such cases are denied access to some relevant information. So that kind of environment that has come down through us either from common practices years and years ago, the Florida, South District of Florida operating under a secret manual that dated from the 70s that nobody even really knew about, even some of the officers of the court. But that kind of environment of automatic or reflexive secrecy, plus the added pressures that we have today from terrorism, from, as we heard in the previous panel, cases that have to do with gangs, with the mob, and that sort of thing is all there. Plus we have the other kinds of cases, right, that now is a whole area of emerging sealing, and that has to do with divorce settlements. So I worry about what the court is faced with as all of this unfolds, because we have a habit of secrecy, both from the public viewpoint, the press viewpoint, and the court's viewpoint, that is hard to break.